resume in public session, and if I could just mention to our guests and remind members to please switch off your mobile phones. They interfere with the recording equipment. The purpose of this morning's engagement is to conduct pre-legislative scrutiny of the general scheme of the Sex Offenders Amendment Bill, which is a government bill, and a private member's bill of the same title, the Sex Offenders Amendment Bill 2018, sponsored by Deputy Maureen O'Sullivan, our colleague who is seated amongst you here this morning. Now, I'm pleased to welcome Deputy O'Sullivan before us here, and we will be opening with Maureen's opening contribution. We're also joined from the Probation Service by Mr Vivian Gearan, Director, Ms Ita Burke, the Deputy Director, Mr Brian Jack, Assistant Director, and you're all very welcome here this morning. And from the Police Service of Northern Ireland, we're joined by Ms Barbara Gray, Assistant Chief Constable. In the Crime Operations Department, and Ms Paula Hillman, Detective Chief Superintendent, who is also Head of the Public Protection Branch, and Mr Ryan Henderson, Detective Superintendent. And you're all very welcome here indeed. You're following some of your colleagues who have been with us most recently, and we're delighted that you've joined us here again on this very, very important issue. From the Rape Crisis Network Ireland, I want to extend a very warm welcome to Ms Caroline Coonahan, the Legal Policy Advisor, and from the University of Limerick School of Law we are joined by Dr Margaret Fitzgerald O'Reilly, and you're both very, very welcome here as well. So, as I've said, you're all very welcome, and we shall invite short opening addresses from each of you. If the order in which I've indicated there in your welcome suits, there's no special ordering of it, but it just will work easiest for me, if that's okay. But first I must draw the attention of our witnesses to the situation in relation to privilege. Please note that you are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you were directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise or make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable. And members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. So, as I've indicated, the format is that Deputy O'Sullivan will outline her bill first, and Deputy O'Sullivan, as with all the other members, is a very busy member of these houses, and she's free to leave thereafter or whenever she so chooses, at her own comfort. And I will also add, Maureen, you're very welcome to stay for the duration as well, if that was within your gift. Now, our witnesses then can address both bills in their opening statements, and I will introduce Deputy O'Sullivan first. I'll then, I think, go on to Mr Gearan, am I correct in saying that? And then on to Assistant Chief Constable, Ms Gray, are you taking lead? Thank you. And then Ms Coonahan, and then Dr Fitzgerald O'Reilly. So, that's given you all prior notice in relation to your opening statement, so it gives me great pleasure, Maureen, to welcome you before the committee here this morning and to invite you to make your opening address.
Okay, so I'm very grateful for this opportunity. So I just thought some general points and background first, and I'll go quickly through it. We know about our own past when it comes to protecting and guarding children, and how much that leaves to be desired. We've had all the events in the industrial schools, the mother and baby homes, Magdalen laundries, foster homes, but Ireland has come a long way in terms of ensuring safety of children, and we've seen the progress that has been made in terms of child welfare and protection. And even though there's still room for improvement in Ireland, we can only imagine what it must be like for children in those countries where they don't have protection, no child welfare and no safeguards. So this bill is about trying to protect children who are easy prey for sexual predators in countries where the authorities cannot or will not protect them from those convicted of sexual abuse in Ireland. The UN Convention on the Rights of the Child recognises the child as being a person under the age of 18. Child abuse is also about trafficking, which is the third biggest illegal industry after arms and drugs and accounts for billions of dollars annually. And statistics indicate that some 2 million children are lured or abducted into sexual exploitation, which is modern-day slavery. The report by Ending Child Prostitution and Trafficking, ECPAT International, states that child sex tourism has drastically increased. And it's a real incongruity that we talk about children and sex tourism in the same sentence. One of the main reasons is that the increase in global travel has created more opportunities for abuse. The offenders are generally white, Western, middle-aged men. Sorry, that should be with some women, of some means, also women offenders, and then we have the situational offender. The promotion of tourism in these poorer countries for economic growth is bringing more and more Westerners to places in which there's little or no regulation or policing, but more and more children available for sex. And we know the countries involved: India, Southeast Asia, Latin America, South America, the Caribbean and Africa. There have been many high-profile cases, but I'm just going to mention one that I mentioned already when I was speaking on this, and that's of a 7-year-old child who was sold to a former American Marine. The former Marine was eventually extradited from Southeast Asia and is serving a very extensive prison sentence in the United States. We also have records of the sale of virgin girls and of organised sex rings. And there's evidence of organisations offering sex tours with stops at bars and restaurants that are a front for child prostitution. Now, the impetus for this bill came from meetings with Irish priest Father Sheikh Colm, who's directly involved in rescuing children from the sex tourism industry in the Philippines and supporting children affected by it. And we all know the consequences for children: physical, emotional, psychological. There's been cases of suicide, attempted suicide, depression, addiction, and sexually transmitted illnesses. At a press conference I was at with him, he spoke of what's been happening through the dark web and the rise in child pornography. To join a photo-sharing paedophile club in the dark web, applicants must submit pictures of children being abused. Some clubs insist on the applicant showing himself perpetrating the abuse. And to get the images, men travel to countries where there's ample opportunity to photograph and video such abuse. The images then give them a pass to access further unlimited images. This requirement to provide pictures is fueling travelling to poorer countries. We know that cybersex is on the increase. Father Cullen spoke about 5- and 6-year-olds being abused in this way over the internet. The abuse is carried out to order. Customers around the world pay per view through money transfer companies. And then just to give the example from Australia, 2017, it emerged some 700 to 800 Australian male convicted child sex offenders were travelling annually to countries in Southeast Asia, like the Philippines, Cambodia and Thailand. So following that revelation, the Australian government acted by passing the Passports Legislation Amendment Act in 2017. It was introduced in the Australian Parliament on the 14th of June 2017, passed both houses on the 20th of June and received assent on the 26th of June. So it allows a competent authority of the Australian Government to request its Minister for Foreign Affairs to refuse to issue, to cancel or to order the surrender of a person's Australian passport if the person's name is on a child protection offender register. And of course that is to prevent reportable offenders from travelling overseas to sexually exploit or abuse vulnerable children. So coming to my bill, it's a tricky situation for which to legislate because of the constitutional right to travel. And although it's wonderful to have the right to travel, that constitutional right was never intended to grant a right to travel to a person to abuse children in other countries when that person has been convicted of child sexual abuse in his or her own country. So the purpose is to regulate and restrict, where appropriate, sex offenders from travelling abroad in the interests of the common good and to protect persons from serious harm outside the state. And it seeks to do that by increasing the powers of judges, so it's not an outright ban on travelling. It relates to those convicted of child abuse, whether it's a physical act of abuse with children, using child pornography films, child abuse images, recordings on phones. It's recognising the constitutional right to travel, but also the need to protect children abroad. The restriction provisions will be decided on a case-by-case basis by a judge who can weigh up those issues. There is a lot of constitutional protection. The convicted person is heard and represented. The judge can also hear if the offender has been genuinely engaging with a recognised rehabilitation programme. It will be the judge who will strike the balance between the Constitution and the protection of children outside Ireland from those convicted of child abuse in Ireland. I'd suggest that it's not so much about punishing the sex offender in relation to travel as protecting children. Because when you look at the facts of the growing child sex tourism to holiday destinations like Thailand, Philippines, other places, I'd have to question the current freedom of sex offenders to travel to those places. And then there's also the frame of mind of the said offender when they return to Ireland from a place that's normalising abuse and exploitation of children. There are just 2 sections in the bill, a subtle difference between sections 4 and 5. The narrow remit, for obvious reasons, but basically it's focused on giving powers to judges, empowering them on the evidence of child abuse to impose conditions, travel limitations at the time of sentencing or later when the judge is satisfied that there is or is not a risk of offending abroad. So one example, a convicted sex offender may have leave to travel to England, for example, for a few days for a funeral, family event, but not to a country where there is known child abuse. So in conclusion, it's a small step, but I think it would be a clear signal that Ireland, and we would be the first country in Europe to do so, does not want its child offenders to be in a position to offend in other countries where child abuse is happening with impunity.
Thank you very much indeed, Deputy O'Sullivan. And could I just, on behalf of the committee, record our appreciation of your own efforts. You're, as an independent deputy, putting in that body of work and coming forward. In fact, perhaps being the catalyst for why it's being addressed at all in the more substantive way, we'll say, in terms of the government bill also before us. So thank you very much indeed. I'll now go on to Mr. Gearan to make the opening statement, please. Yes.
Thank you, Chairman, for this opportunity to contribute to the committee's deliberations on this legislation. I'm joined today by my colleagues, Deputy Director Ms Ita Burke and Assistant Director Mr Brian Dack, and I propose in these opening remarks to highlight some key issues in relation to our work with sex offenders, which may assist the committee. We will, of course, be more than happy to answer any questions and engage in further discussion on any matter as the committee sees fit. The Probation Service is an agency of the Department of Justice and Equality. The 2 primary areas of work undertaken by the Probation Service are offender assessment and offender supervision. I propose to move on now to our work specifically with sex offenders. Since the publication of the discussion document of the Working Group on the Integrated Management of High-Risk Sex Offenders by the Department of Justice, Equality and Law Reform, as it was then in 2009, integrated interagency and multidisciplinary services have been developed significantly. Our focus is now on effective risk management, incorporating assessment, supervision, support and the monitoring of sex offenders to reduce the risk of both reoffending and the harm that any further offending would cause. The Probation Service is currently managing 264 sex offenders in the community. The courts, prior to sentencing, frequently request a probation officer's pre-sanction assessment report on offenders who have pleaded or been found guilty of a sexual offence. The assessment report identifies issues relevant to the risk assessment and risk management of the offender. Many convictions for sexual offences attract an immediate custodial sanction. These sanctions may also include an appropriate community sanction element with supervisions conditions post-custody. To improve the coordinated interagency management of sex offenders, the Sex Offender Risk Assessment and Management, or SORAM, system was developed by An Garda Síochána and the Probation Service for the joint assessment and management of the risk posed within the community by convicted sex offenders. The model itself allows for enhanced working relationships between the personnel in relevant agencies, a structured approach to risk management, a coordinated intervention with the offender, higher levels of monitoring, higher levels of appropriate information exchange, more accurate risk assessment and enhanced child and public safety. The Probation Service welcomes the proposed new Section 14A in the Principal Act, Head 9 in the current general scheme, that places the assessment and management of risk posed by sex offenders on a statutory basis. It will further strengthen the current SORAM arrangements and make obligatory the sharing of risk-relevant information between the relevant players. Multi-agency approaches to managing the risks posed by sex offenders are essential. The Probation Service, in partnership with a number of non-governmental organisations, supported through the Department of Justice and Equality, provides a range of additional support services to further assist in the management of risk posed by this category of offenders and their integration in society, and we've included some of those in the paper. Placing the victim to the forefront of our work is critical, and developing a victim perspective in the offender is paramount. While our expertise is directed primarily towards offender rehabilitation as a means of reducing victimisation, we recognise that focusing in this way on the offender can lead victims to feel that their safety, rights, needs and interests may not be prioritised. This should not be the case. Survivors' advocacy groups work closely with us on initiatives such as Circles of Support and Accountability and our therapeutic group work programmes. Other restorative justice approaches include victim offender mediation where appropriate, and we facilitate such approaches where appropriate, but only after careful and often lengthy preparation. In conclusion, public protection is the key principle underpinning the management of sex offenders sentenced to prison and under the supervision of the Probation Service. Therapeutic interventions in prison are in place, including individual and group counselling and offence-focused work from the Irish Prison Service Psychology Service in partnership with the Probation Service. Within the community, the Sex Offender Risk Assessment and Management Arrangements, SORAM, provide an integrated, multi-agency approach to this work. Both statutory and non-statutory partners collaborate in this endeavour. Changes to the legislation, as proposed, will hopefully lead to further developments in responding effectively to sexual aggression and violence, and such refinements to the Sex Offenders Act 2001 will, among other things, strengthen the ability of statutory agencies in managing sex offenders by placing SORAM on a statutory basis. Thank you very much.
Well, thank you very much indeed, and our gratitude also to the Probation Service in the preparation of the even more substantive body that you've presented in the circulated statement. Before I introduce Assistant Chief Constable Ms. Gray, I've just noted the fact that not all my colleagues are identified in lights here this morning. Now, Senator Conway and Deputy O'Callaghan's names are there, but there's some glitch in the electronics. So I couldn't let the moment go by but to introduce Deputy Mick Wallace, who his name is not up in lights this morning, but he's there, Deputy Clare Daly, and Deputy Donegal Leary. And we will try to have the electronics sorted for next week's meeting. So without any further ado, I would like to invite Assistant Chief Constable Ms. Barbara Gray to make the opening statement on behalf of the PSNI. Thank you.
And thank you very much for the warm welcome here this morning. My name is Barbara Gray. I'm Assistant Chief Constable for Crime Operations. Covers organised crime, serious crime, the Public Protection Branch. I also have Intelligence Branch and Specialist Operations Branch. And I'm relatively new to post, having just taken up in the recent weeks from September. I've got Detective Chief Superintendent Paula Hillman with me today, who is the head of the PSNI's Public Protection Unit, and Detective Superintendent Ryan Henderson. And I think it's important to put on record today that an apology. Alan Smith, who is from Prison Service, but he's currently the chair of the Strategic Management Board, which is under our public protection arrangements in Northern Ireland, would have liked to have been here today, but unfortunately he can't. But I think that encompasses some of the multi-agency work that we do. So in Northern Ireland, the Criminal Justice Northern Ireland Order 2008 established the statutory basis for public protection. These arrangements are known as the Public Protection Arrangements Northern Ireland, PAPANI as we call it, and in England and Wales and Scotland there are similar arrangements, also known as the Multi-Agency Public Protection Arrangements, or MAPA as we call them. The arrangements involve agencies working together and sharing information to better protect the public in a coordinated manner. The legislation, however, does not form a corporate body to deliver these. The relevant criminal justice agencies, such as the Police, Prison Service and Probation Service, and others which include the Health and Social Care Trusts, deliver their own statutory responsibilities and obligations relating to public protection in a joined-up and cooperative way. It's also important to note that the public protection arrangements do not replace existing child protection procedures. The PAPANI arrangements which I refer to are governed by a strategic management board, and that is made up of senior managers from all lead agencies, including 2 lay advisors. The board is chaired alternately on a rotational basis by PSNI, the Probation Board for Northern Ireland, or the Northern Ireland Prison Service, and currently it's chaired by Prison Service, and responsibility will transfer to PSNI to Chief Superintendent Hillman in April of next year. The eligibility criteria for inclusion within the public protection arrangements are as follows. Persons who are subject to the notification requirements of Part 2 of the Sexual Offences Act 2003, or who have been convicted of a sexual offence or sexually motivated offence and are not subject to the notification requirements of Part 2 of the Sexual Offences Act 2003, but about whom an agency has current significant concerns. Persons who have, from the 6th of October 2008, been convicted of a violent offence, including homicide, against a child or vulnerable adult, or who have a previous conviction for a violent offence against a child or vulnerable adult, and about whom an agency has current and significant concerns. It also includes persons who have, from the 1st of April 2010, been convicted of a violent offence, including homicide, in domestic or family circumstances, or who have a previous conviction for a violent offence in domestic or family circumstances, and about whom an agency, again, has significant concerns. From the 1st of July 2013, new referrals into PAPANI of violence in a domestic or family circumstances must have a minimum conviction of assault occasioning actual bodily harm. Persons who have, from the 1st of September 2011, been convicted under certain circumstances of a violent offence, including homicide again, and received an enhanced sentence, and where the offence has been aggravated by hostility, and about whom an agency has significant concern, and persons subject to a risk of sexual harm order. Within the PAPANI arrangements, offenders are categorised as Category 1, 2 or 3, and 3 is deemed to pose the highest level of risk of harm. Where an offender is assessed as meeting the criteria for Category 3, management of that case is allocated to the co-located public protection team. The public protection team consists of line managers and practitioners from the PSNI, the Probation Board and Belfast Health and Social Care Trust. The aim of the public protection team is to provide for a consistent level of management of risk for those offenders in the community who represent the greatest cause for concern. The different disciplines within the public protection team allow for the delivery of a tailored risk management plan alongside an individual intervention and support plan aimed at developing the offender's internal controls. Each year, PAPANI are required to produce an annual report outlining the work undertaken by the relevant agencies involved in public protection, and has recently published an analytical profile of offenders subject to PAPANI arrangements. The policy and working arrangements for public protection in Northern Ireland are contained within the comprehensive manual of guidance, the PAPANI manual of guidance. So, turning to the aspects of the proposed legislation that were highlighted within the invitation for today, I thought it would be helpful to highlight just a few pertinent points around that. With regard to the notification requirements, in Northern Ireland, the Sexual Offences Act 2003, as amended, requires all PAPANI eligible offenders to notify within 3 days of being informed of their requirement to do so. And the 3 days starts at midnight on the day that they were informed. In order to notify, they must attend a police station, and they are required to notify a number of matters, which include an address at which they'll be living, and includes any absence in detail of more than 3 days from that address, and that includes travel arrangements and accommodation arrangements during their absence. They must notify of proposed travel arrangements outside the United Kingdom and provide fingerprints and permit a photograph to be taken to confirm their identity. And in practice, these requirements work well. With regard to the statutory basis for disclosure of information relating to an offender, offenders are encouraged to disclose details of their offending where appropriate and allow this disclosure to be verified. If an offender refuses or the disclosure cannot be verified, then existing agency powers will be used, such as child protection protocols utilised by our social services colleagues. If no power exists, then a PAPANI disclosure form will be commenced, and in such cases a PSNI Chief Constable is responsible for making the decision regarding disclosure. The Justice Act 2015 also introduced the Child Protection Disclosure Arrangements. Under these arrangements, a person may apply for conviction information where there are concerns regarding a named person and named children. If the criteria are met, then disclosure is made to the person best placed to safeguard the child. Again, these arrangements, we would say, work well in practice. With regard to the provision of a statutory basis for electronic monitoring post-release of sex offenders, there is no specific legislative provision for the electronic monitoring of sex offenders pre- or post-conviction in Northern Ireland. There are, however, general powers relating to electronic monitoring applicable to all offenders. The basis for electronic monitoring of offenders in general is found within the Criminal Justice Northern Ireland Order 2008. And the legislation provides the power to impose a curfew or electronic requirement in the following circumstances: where a condition of bail can be granted by a court, a condition of a licence specified in Article 35B of that order, or a requirement of a probation order or youth conference plan. So with regard to the proposal to regulate and restrict offenders from travelling abroad, foreign travel orders are set out in the Sexual Offences Act of 2003 as amended. And where there are concerns that a specific child or children in general are at risk of serious sexual harm from an offender, we can apply to court for a foreign travel order, which prohibits the offender from travelling to the specified country or any country outside the UK. Pardon me. The offender will be required to surrender his or her passport, and the offender must be a qualifying offender, which in the main is an offender who has committed a sexual offence against a child or offences relating to indecent images or material relating to a child. In order to meet the threshold for a foreign travel order, there must be grounds to believe that the offender travelling to a certain country poses a risk to children. It is our understanding that there are no current plans for legislative change in Northern Ireland at present in regard to the management of sex offenders. And if any such changes were planned, consultation and implementation would be progressed through the multi-agency public protection arrangements and that strategic management board, which, as I say, will be chaired by Detective Chief Superintendent Hillman from April of next year. So thank you.
Thank you very much, Assistant Chief Constable. Thank you for a very informative opening statement, and we look forward to engaging with the members shortly. So that brings me on now. I'd like to invite Ms Coonan to make her opening statement, please.
Thank you very much, Chairman. And could I say thank you very much to the committee for inviting a representative from Rape Crisis Network Ireland to be here today. We're very grateful for the opportunity. And I suppose I would say our concern with regard to sex offenders is twofold. First of all, to do all we can, little as it is, to help ensure that the risk from sex offenders in the community is reduced as far as possible, and that those responsible for their monitoring, support and supervision have the range of powers available to them that they need to do their job. That's the first thing. And the second thing is a little bit more nebulous, but it's very important just the same. It's our concern is to ensure we do as much as we can to ensure that victims of convicted sex offenders do not feel vulnerable or powerless once the person who is responsible for the offence against them is released into the community, but that they know that there are things that are being done, and perhaps in certain cases where more can be done. So broadly, we welcome very much these two pieces of legislation. Certainly the general scheme seems to be very comprehensive. I'm just going to go through a few of the heads to highlight some of our recommendations and also to give you the rationale for why we made them a little bit. Head number 1 on the notification requirements, head number 5 on notification requirements. We welcome very much the broadening of powers here, and also because over the years we've heard a lot from various members of Garda Síochána about the vagueness of the current Act on the exact detail of how reporting should take place and what happens in special situations where somebody is homeless, or they might be disabled, or they might be detained outside the jurisdiction. There's a lot of clarity here. We welcome that very much. The only small comment we'd make here is perhaps you might consider including an extra requirement of notification that the sex offender provide any address at which he regularly resides or stays, as well as his main home address when he goes to notify a particular member of Garda Síochána. We single out also head 9. I just want to echo really what the probation service has said, because I think it's very good that it's been put finally on a statutory basis, the whole process of risk assessment and risk management. And we would say that it's very important that there be effective liaison with local NGOs supporting victims, not just rape crisis centres, but also others. And why is that important? It's important to our clients because it's important that they are well informed and informed by the responsible officials about what is being done to supervise and monitor sex offenders in the community. And also it's important that if, heaven forfend, they do have concerns in the future about the behaviour of a particular individual, that they know what to do with those concerns. I suppose the general principle is to try and counter the culture of fear and the feeling that one is helpless, and that in fact people who take the law into their own hands, well, it's not the right thing, but you can understand why they did it. We have to counter that in the interests of good risk management. I suppose I would say also, looking at the way the head is drafted, with great respect to the drafters, I feel that the risk management role, which is so important and which goes on for a long, long time, should perhaps be stressed in the language a bit more, and we say perhaps call them risk assessment and management teams. And we suggest also that there might be a mechanism included in there for receiving information from third parties, which sometimes people come into possession of information and they think, oh my God, that's really scary, I'm not sure what to do with that. It would be great if there was a place that they could go with that. With regard to head number 10, disclosure of information, I see that there's a number of, how shall I say, a kind of brakes put on the process of disclosure, where there's a risk of vigilante activity being the result of the disclosure. And we would say that another thing which should be included on that list, I mean, I'm sure this is very much the forefront of the minds of the particular Garda in question, but nevertheless, no harm to have it in there, that there might be a brake put on disclosure where there's any risk to a present or potential future investigation or prosecution, because it would be devastating for survivors if a possible prosecution were jeopardised by inappropriate misuse, well, just misuse of information which had been disclosed in this manner. And we think also, consideration should be given to putting in there actually a sanction for misuse of information. And finally, with regard to the general scheme, I'll come on to the bill in a minute, head number 18, prohibition orders, very welcome that there's a proposal to introduce orders preventing people who are convicted of a sex offence from working with children or vulnerable persons. I suppose I have two comments really about that. The first is the general one. Should these orders not be coextensive with notification requirements? That is, as long as somebody is a sex offender, should it not be the case that they should be precluded absolutely from working with children or vulnerable persons? And I suppose I'd be concerned also about the way that this is drafted. The way it's drafted, if somebody is convicted of a sex offence for which the maximum penalty is not life, but say, in the case of sexual assault, say 10 years, and gets quite a high sentence because perhaps they're a repeat offender, perhaps they were found guilty, perhaps a combination of the two, perhaps it was extremely serious. Suppose, for the sake of argument, they get a sentence of 8 years. Well, with remission, that person will be out in 6 years, and 6 years plus the remaining possible term of the prohibition order can't go beyond the overall maximum of 10 years. Therefore, that person will only be precluded from working with children for 4 years. It's almost as if he gets a reward for behaving worse. So this cannot be the intention of the legislation, and with great respect, I think I'm suggesting the simplest way to fix it is just to make prohibition orders, as it were, part of similar to notification requirements, that one is subject to them as long as one is subject to notification requirements. And one final small point on the general scheme as a whole: discharge of orders. It has come to our attention several times. People who have been the victims of sex offenders get very upset when these offenders apply, for instance, to no longer be subject to notification requirements. There are several places in the general scheme, as in the current legislation, where there are discharge provisions. I have no objection to people applying for discharge, but I really do think it would be right if people would, on any of these applications, somebody would get the opportunity to be heard as a victim of sexual violence. I think that should be in there. And finally, oh dear, in relation to Deputy O'Sullivan's bill, we welcome it very much, as you can imagine. In principle, I think it's a terrific idea, and I note with great interest what's happening in Northern Ireland as well, and I think surely if it's happening in Northern Ireland, it ought to happen here. I suppose I have a small concern, and maybe I'm wrong to have this concern, but nevertheless I have it. I just wonder if it should not be framed in a more tight fashion, if there should not be a clear threshold, as for instance there is under the proposed, I think it's section 26C in relation to prohibition orders, that and indeed as it is framed in the Northern Irish foreign travel orders, that there should be a threshold that has to be overcome before such an order can be made. And I say this just being mindful of the right to travel in the Constitution, and my thinking is it might be wise to insulate this provision as far as we can from attack on the grounds that maybe it's unconstitutional or it's oppressive. because it would be great to have it. It would be a terrific addition to the armoury that we already have. So thank you for your patience.
Well, thank you, Caroline Coonan, and we'd also like to record our thanks to the Rape Crisis Network Ireland for the submission. Thank you very much indeed. And that brings us on to our final guest speaker here this morning. And before inviting you, Dr. Fitzgerald O'Reilly, it occurred to me that over the course of this year, the Limerick School of Law have occupied a seat before this committee on a number of occasions. So there must be something special going on down in Limerick in this regard. So in follow-on to your colleagues who have been with us before, you're very, very welcome here this morning. I'd like to invite you to proceed.
Perfect. Thank you very much. I would like to thank the committee for inviting me here today. I very much welcome the opportunity to be able to discuss the changes proposed under the Sex Offenders Amendment Bill, as well as those in relation to the Private Members Bill also. I'm going to focus upon 3 of the proposed amendments today. The first is in relation to the Private Members Bill, and the purpose of which is to regulate and restrict sex offenders from travelling abroad in order to protect persons from serious harm outside of the state. These proposals echo similar provisions available elsewhere, such as in the UK, the US and Australia, which have in some way sought to ban or restrict the travel of sex offenders abroad. The rationale for such provisions is that individuals who have offended against a child pose an extremely high risk of reoffending, and that these laws will stop them from doing so. Perceptions of dangerousness are overestimated to some extent, and studies in Ireland and elsewhere have shown that sex offenders actually have low recidivism. The effectiveness of such laws are also in doubt. In 2016, a global study on sexual exploitation of children in travel and tourism found that sexual exploitation of children in such circumstances is a mainly domestic and intra-regional crime, and that situational and domestic offenders account for most cases of such abuse, rather than international preferential offenders. So while some abusers are paedophiles, most are not. Most are situational offenders, as in those with no prior history of sexual offending against a child. While child sexual abuse and exploitation is and should be an important policy concern for lawmakers, it does little good to enact laws and impose requirements such as travel bans or restrictions when there is no evidence to suggest that such laws are effective in reducing the risk to those that they aim to protect. It is also necessary to consider rights such as the right to travel, the right to liberty, and the right to privacy and family life under both the Constitution and the European Convention on Human Rights. Constitutional and/or human rights violations may be found as a result of arbitrary, unnecessary and disproportionate interference with such rights. In particular, these provisions could give rise to an unjustifiable interference with privacy and family life under Article 8 of the European Convention, and perhaps even with earning a livelihood, where the individual has to travel for work or to enjoy family life, for example in a cross-jurisdictional context. If restrictions rather than a complete ban are to be placed upon travel, it needs to be made clear how these will be imposed and implemented so that they will not be considered to be arbitrary and unnecessary. Any restrictions imposed will require increasing the quality, quantity and regularity of the information shared with other jurisdictions in relation to the child sex offender in order to effectively oversee the movement of offenders who travel abroad. At a practical level, this may be difficult to achieve because it becomes a resources issue. Overall, I would suggest that the circumstances which would give rise to these restrictions need to be clearer, an evidence-based risk should exist, and the restriction or ban must be deemed to be proportionate and necessary in all the circumstances. And this could be expressly incorporated into the wording of the provision. The second point relates to Head 10 of the main bill, which relates to the issue of community disclosure. I very much welcome legislative clarity relating to the disclosure of information to the public, as well as the controlled disclosure approach being proposed. Generally speaking, disclosure laws are enacted with the objective of preventing recidivistic sex crimes. Such laws may garner strong support in the belief that knowing where sex offenders are will make us safer. However, the effectiveness of disclosure in this regard has been called into question by countless studies. Empirical research has not uncovered any demonstrable effect on future sexual reoffending. Moreover, rather than reduce fear, disclosure can in some circumstances heighten the fear and anxiety of persons who have received such information. So there is a need for support and follow-on support in such circumstances. The wording of the proposed provision currently seems to suggest that the issue of disclosure rests with the Gardaí and is thus proactive rather than reactive. This may just be my interpretation of it, but I would seek clarity as to whether the provision intends to be reactive in the sense of permitting applications from parents, guardians or third parties. While the proposal is not confined to the protection of children insofar as it aims to protect any person, it is worth noting that equivalent provisions in the UK provide that disclosure will only be made to the person or persons best placed to protect the child or vulnerable adult rather than to the public at large, and I would strongly suggest that we consider such wording in the context of this provision as well, where it's involving protection of a child. Moreover, the provisions do not make any mention of confidentiality of the information once a disclosure has been made. This is notable considering that under Head 9, confidentiality is expressly required in relation to information sharing, albeit in a different context. Confidentiality should apply here, in particular with regard to data protection laws, and this should be incorporated into the proposed amendment. Overall, the provision should expressly provide that disclosure will only be made in exceptional circumstances where considered necessary and proportionate to do so. My final point relates to Head 13 and Head 19 of the main bill, providing for electronic monitoring of sex offenders, either as part of the sex offender order or as a condition of post-release supervision. So the rationale of such a measure appears to be to monitor compliance or to identify risky behaviour. While, of course, measures like electronic monitoring may provide reassurance and are argued to have a deterrent effect, such a measure also naturally raises legal and ethical concerns. Any scheme which proposes to introduce tagging of those who have already served their sentence raises the issue of additional punishment, possibly in breach of the constitutional principle of proportionality. Tagging is far more intrusive than signing on at a Garda station and has a greater impact upon privacy and freedom of movement rights. So a way of reconciling such constitutional concerns could be to incorporate the measure as part of a remission scheme, whereby early release may be granted in conjunction with tagging. Alternatively, the courts should be required to take electronic monitoring into consideration when sentencing, and thus ensuring proportionality in the combined overall sentence. The effectiveness in terms of deterrence or preventing recidivism of this measure is empirically unproven. Evidence that it reduces recidivism is scant, and experience in other countries on a more general level and in relation to monitoring of high-risk sex offenders has demonstrated that it has significant limitations in this regard. There is some limited evidence available in the US and in some jurisdictions in Europe to support the contention that the tagging of high-risk sex offenders may be useful in terms of ensuring compliance with registration requirements, but such measures have no perceived effect on recidivism. Where monitoring reveals a new crime, this tends to be in relation to a breach of registration requirements rather than sexual reoffending. The research shows that electronic monitoring is not cost-effective, and moreover, that knowledge about offenders' whereabouts will not necessarily affect change in underlying criminal behaviour. The support for electronic monitoring has been described by some, and I quote, as a belief in a technology-focused approach as a silver bullet to solving crime and other social problems, but that this provides a misleading assurance of safety. Electronic monitoring is a short-term solution, and while it may address some immediate concerns in relation to individual high-risk sex offenders, it does not provide the means for effectively dealing with sexual offending behaviour in the long term. The best available evidence suggests that monitoring is more effective when it is carefully targeted and integrated with other forms of supports and risk management. So given the lack of research in this area with regard to its effectiveness and its impact upon the monitored person and their family, there is strong argument to be made that there should be an inbuilt evaluation of the impact and effectiveness of this initiative if introduced. In conclusion, there are significant gaps in our knowledge overall of whether these or any sex offender laws have any effect in terms of reducing sexual offending or reoffending behaviour. Sex offenders are most certainly not a homogenous group. They vary considerably in terms of their characteristics and level of risk. And what is sorely needed here are empirically derived risk assessment procedures that would help us to target and more effectively manage those at the highest risk of sexual reoffending.
Thank you, Dr. Fitzgerald O'Reilly. I appreciate your very thoughtful contribution to this morning's deliberations, and I now open up the opportunity to our members. And I've had one indication, Deputy Jim O'Callaghan. Would others like to? Thank you. Deputy O'Callaghan.
Yeah, thanks very much, Chairman, and thanks all very much for coming in. And you all put a considerable amount of effort into the submissions you made to us. and I know that they will be of great assistance to this committee when we come to consider the legislation that is going through the House, or which will go through the House. Obviously, it is a very difficult issue, and I'm conscious that all of you look at it from the point of view of when there has been a problem. Whether you're in the probation service, you're looking at somebody who's been convicted. In the police force, you're looking at somebody who's made a complaint and is being investigated. And the same applies in the Rape Crisis Centre when a client comes before you. So I suppose what we're dealing with here is sex offenders when the problem has arisen. And I suppose from our point of view, like, our primary concern is to protect victims. But I suppose we also have to be careful that we don't categorise a group of offenders as being completely beyond the pale and as though they're not capable of rehabilitation. That's just a preliminary point I'd wish to make. In terms of Maureen's bill, obviously it is an extremely large power for the state to be able to restrict a person from travelling. But I suppose in terms of, Margaret, just in terms of your submission, like, the purpose of the legislation appears to be to try to prevent individuals committing criminal offences in other jurisdictions. Like, is that something that you're aware of is on the statute book at present here?
Yes, and of course there is nothing wrong in the sense of targeting individuals where there is evidence to suggest that they are going to travel abroad and that there is a specific risk. What I suppose we need to guard against is to have a balanced approach, and that involves looking at whether or not making that restriction or prohibiting the person from travelling is necessary, is proportionate in all the circumstances. I think we need to take into consideration the purpose for the travel. So, as I mentioned, in the context where somebody has to travel in order to, enjoy family life, where they're working in a different jurisdiction, I think the purpose of the travel becomes important then to consider, and perhaps that is something that could be incorporated into a redrafting of this particular amendment. And it's more about targeting high risk, as opposed to assuming that every sex offender is going to pose a risk of sexual reoffending once they travel abroad. If they want to go on holidays with their family member, we need to have some sort of evidence-based risk in existence there in order to ensure that we protect.
I'm sure it's also the case that a lot of people who go abroad and sexually abuse children have never had a criminal conviction here. They're probably as big a threat as people who have been convicted.
Absolutely, and that's what the global study conducted in 2016 demonstrated, and that was a study which received submissions from countries all over the world. So in America, Africa, Russia, continents all over Europe, or the countries all over Europe, and the vast majority of those countries were, the same in terms of saying that the majority of abuse here occurs in a domestic setting from offenders who have access to their victims in that domestic setting, or situational offenders. And one particular thing to note in that context is members of military personnel who are resident in the jurisdiction for a time, or people who travel for the purpose of enjoyment, may feel that they are not subject to the same laws because there is such a prevalence of child abuse in those circumstances. And it's about how do we best protect children from those types of offenders. These types of laws are not going to do that because they don't target such individuals.
Okay. Caroline, I was looking at the Head 10, the new Section 14B on disclosure. Do you have any concerns about how this could, in a way, drive sex offenders underground? Where, obviously the purpose of it is it's for the public benefit, that there may be a threat to individuals, so the police and the Gardaí will inform people nearby as what happens. But I suppose if that becomes common, a lot of sex offenders aren't going to stay registered, and they're just going to drift into the ether and not make themselves available to the state. Is that a concern?
That's a huge concern. In fact, I guess I didn't concern myself too much about it on this occasion, Deputy, because I was thinking, if it's all going to be in the control of the Gardaí, and the Gardaí are going to be the ones setting the rules, in effect saying when and to whom and how much shall be disclosed, I can't imagine that would be done without consultation with the local SORAM, first, last and always. In that context, I would have fewer concerns, but I would have a general concern about that happening, because the worst possible thing I have always heard, both from probation and from Gardaí involved in the management of sex offenders, is when they go under the radar. That's when the risk can escalate very, very dramatically and very quickly. So yes, so that's why I suppose I'm concerned about who is going to get this information and what are they going to do with it. It cannot be misused, and I really do think there should be some form of penalty in there for misusing the information. And Margaret suggested that there should be something in there about confidentiality. Yeah, I think it's a very good idea.
And Vivian, does the probation service have any concerns about that? That people may be driven underground if there is this capacity for disclosure there?
Yeah, I would certainly have that concern. Can I just say, going back to your earlier point, I think you're absolutely correct, Deputy, in saying that we are dealing in both pieces of legislation by definition with people who have been identified and convicted and so on, and that is certainly the reality. If I can borrow a phrase from Margaret, there is no silver bullet. No legislation or no technical measure such as electronic monitoring will necessarily in itself stop offending, and it does need to be couched in the whole systemic approach. As far as driving people underground is concerned, that's a serious issue that we face, as Caroline has said, on a regular basis, where offenders who are coming out, for example, from prison under our supervision are sometimes followed from the prison to our office by sections of the media and so on, and then subsequently can have their location outed, and as a result may go underground, and that would certainly be a difficulty and doesn't help in any way the rehabilitation process.
And also they're a bigger threat to the public when they're underground and you don't know where they are, isn't that correct?
Definitely.
Can I just ask Assistant Commissioner Gray, and thanks for coming down, by the way, just in respect of electronic monitoring, that we have it on our statute book here, and it's only been used really on pilot basis. You say in your statement that it's not used exclusively for sex offences, it's used generally for offences. Is it used for bail in Northern Ireland, for the purpose of monitoring people on bail and as a condition of bail?
Yes.
It is? Okay, yeah.
It's used in that pre-court phase, can be used by the court as an alternative to remand in custody.
Yeah.
So it's used in that space.
Okay. So I think it is important that sometimes when people present monitoring, it's presented as though it's an additional penalty. Like I suppose our contention would be it shouldn't be seen as an additional penalty, it should be seen as an alternative to incarceration, and sometimes that's the way it operates in Northern Ireland.
And in the post-sentence and release phase under licence, it similarly can be as an alternative to a longer time in custody, for example.
I just want to say, like, I'm obviously a Fianna Fáil spokesperson. We work here collectively as a committee. Like, I'm supportive of both pieces of legislation, but I think it is a very complicated and complex area. And, I think we need to be careful in how we approach it. And I suppose, as I said, you all get involved after a problem has arisen. Like, I suppose there's a bigger question for society, which is what is causing people to engage in sexual offences, sexual attacks. And I suppose this generation of young people are exposed to pornography and the internet and technology to an extent that no previous generation was exposed to it. And we do not know as of yet the impact, particularly on young men, that the prevalence of pornography and the very submissive and malleable way it presents women is having on the development of their sexuality. So I just think it's an area that we need to do considerable research into, and I welcome the fact that the ministers were going to have a new SAVI report in respect of it. But as you said, there's no simple solution to this. Research is the answer, but I do think it's important that we don't categorise people who are sex offenders as people who should be put in a bin and we should never seek to rehabilitate them. I know no one's suggesting that, but it's a difficult, complex. Obviously, the first requirement is to protect the public. But it's interesting that the recidivism levels for sex offenders are considerably lower than for, say, burglary or crimes of property. Isn't that correct? That's my understanding of it.
Accept.
Is that correct,
Yes,
Caroline?
yes,
am I wrong about that, Caroline?
It's just, I can't give you chapter and verse right now. I must go away and
Yeah.
look it up. But I think it was Dr. Ian O'Donnell who did a paper on this. And he found quite right, low levels of recidivism after, I think it was a 4-year period.
Yeah.
But then he went into a bit of a discussion and he referred to various other pieces of research, and he said that if you extend the period, then the recidivism rate goes up. And then it's also very important to distinguish between reoffending and reconviction. Because don't forget, sexual violence is not often reported, even with very good
that's a fair
supports.
Point. Yeah.
So therefore, there's going to be fewer people reporting it for a whole variety of reasons. Anyhow, so actual reporting, reports, investigations, prosecutions, convictions, it can't be the only measure, really. Like, how do you say? It's not the same as reoffending. The only thing that is concrete is the reconviction. But reconviction is the least likely outcome.
That's correct.
Yeah.
I suppose you can...
Not to miss out on another response. Detective Superintendent Henderson, please.
I would like to, if you don't mind, Chair, return to the issue of disclosure. Perhaps just to give you, I suppose, a practical illustration around disclosure. And the legislation that we're discussing is incredibly important because it gives preventative parameters to offenders and also some high-level powers of last resort. But there are layers of process and practicality underneath, and the key relationship is the relationship with the designated risk manager or the offender manager. And actually our whole processes are based around encouraging voluntary disclosure, encouraging the offender to take ownership of some of those decisions. So in reality, in getting to the legislative power is very much in extremis and very rare, because there are other processes, I suppose, of nurturing and coaching. The same around the notification requirements. You know, it's very much, we see our role as supporting offenders in terms of knowing what it is they're required to do. So to see the legislation simply as the thing that is controlling the management of sex offenders, in practical terms, it's that individual relationship is very, very important. And in terms of disclosure considerations, all of the things that you have said in terms of being really concerned about how that information might be used are very important. We don't see sex offenders going to ground for fear of disclosure because of that relationship that we have.
Thank you very much. Thanks, Chairman.
Okay, and may I just, I should have at the outset said that while Deputy O'Callaghan was being particular to each of you in turn, if anyone wanted to add a supplementary point or anything else, just indicate and we'll most happily involve you. Thank you, Deputy. And our next questioner is Deputy Clare Daly. Please.
Thanks, Chair, and thanks very much for coming in. And I have to go out for a priority question, but I'll be back as well. So sorry for the disruption. And I think it's an incredibly important discussion and a really difficult one, actually, because there's nothing like, you know, sex crimes, particularly in relation to children, to raise the hair on the back of their neck and everybody to go up in arms. And the sort of, we know that because of the abhorrence to the crime, identifiable sex offenders have been the subject of being beaten up, of being targeted, of driven out of their homes, and all the rest of it in massive scare tactics, which actually don't do anything at all to protect anybody. But it is that gut reaction. And I suppose my first question is really that in the context of these pieces of legislation dealing with known sex offenders, in other words, a tiny minority of the people who commit sex crimes, in a manner in which we've heard evidence today, probably does so in an ineffective way. It's difficult to police or guarantee these things. Are we actually even wrong in tabling these now in a piecemeal approach? Because are we given the illusion then that these pieces of legislation give a protection that they actually don't? And would society not be better served by having that broader discussion of the supports that are necessary, that we try and find out why do people commit these crimes and how can we address them? That is the legislation in that sense premature and unhelpful? Because on its own, what is it going to achieve? Now, maybe that's a bit dramatic, maybe, but just to throw that there out as, I suppose, the first point.
Who would you like to direct that to
anybody,
first?
Really.
Any
Anybody.
takers?
I mean,
Please, Mr. Dack, I think you were the first hand I noted, and you can talk to Vivian afterwards and clarify between the two of you.
Thank you, Chair. I mean, one part of the legislation, which is the placing of SORM on a statutory basis, we think is very, very important. And we've been operating SORM on an administrative basis since 2010, and we've had a lot of contact with our colleagues in Pepani, and a lot of what the Assistant Commissioner here beside me has spoken about is mirrored in the administrative way we do things, and increasingly we've brought other partners into the SORM arrangements. So while it started off with An Garda Síochána and the Probation Service, now we have a National Steering Committee which is represented by the Probation and An Garda Síochána, but equally the Prison Service, TUSLA, the Child and Family Agency, the local authorities through the local authority manager, and we have representation from survivors advocacy groups as well at that national level, and then we have a joint co-located office which has An Garda Síochána, the Probation Service, TUSLA, and the local authorities and the Prison Service working together in Harcourt Square. We work closely too with the NGO sector because that's the facilities, they provide supportive facilities to the sex offenders that we deal with in the community. And I think to put it on a statutory basis would be very, very helpful for us, because it would allow increased cooperation and communication between us. So while I take your point that changes have taken place in different pieces of legislation, we certainly would welcome this particular aspect being brought forward.
Would you like to add something?
Yeah, just to add in a kind of a general sense, Brian has described the specifics of the sex offender risk assessment and management, and just to say that while earlier on I did say that there isn't any silver bullet, I wouldn't want people to go away thinking that legislation isn't important. So the 2001 Sex Offender Act is really a foundational and really progressive piece of legislation that helps us all working in this sphere to assess and manage sex offenders. And the two pieces of legislation currently being considered would represent very significant updates to that legislation. So I would just emphasise that legislation is one very important foundation for the work that we do. And as Brian has said, just one example would be that it would put a certain element of what we do on a statutory basis, which would be welcome, and the various other provisions would be also welcome.
Thank you for that. Margaret, please.
Thank you very much. I echo those sentiments, and I think there are some aspects of both bills that are certainly very welcome in terms of improving kind of the legislative quality in terms of laws that we have available to help address some of these fundamental issues. I think, though, overall, I understand the nature of that sentiment as expressed by Ms. Daly, because there has to be a question of, if we want to protect the public, how do we best do that? And do these laws provide the means for effectively protecting people from sexual offending or sexual reoffending? And in terms of answering that question, we have to look at the evidence that is being produced in other jurisdictions. Now, I'm going to just take the US as an extreme example, obviously very different context, very different jurisdiction, but have had notification laws in existence since the 1940s. Megan's Law, which is the very notable public disclosure law, has just passed its 20th anniversary as of 2016. And studies conducted into the effectiveness of these SORN, as they're referred to, sex offender notification and registration laws, demonstrate that there is no appreciable impact upon deterrence, upon reducing recidivism, that inherent in different empirical studies done in different jurisdictions between groups that are subject to these registration requirements and groups that are not, there is no appreciable difference in terms of recidivism rates. And that has to be something that we have regard for. So in terms of effectiveness in helping to address the broader issue and the long-term issue of sexual offending behaviour, we have to question, and I think it's right that we question whether or not things like notification laws and disclosure laws are going to help us to do that. Now, to some extent, in relation to issues of disclosure, for example, I think the approach of controlled disclosure is to be advocated. I certainly would hate to see us move towards a widespread access, and I don't think that's being suggested at all, because it has been demonstrated to be profoundly unhelpful and counterproductive to a lot of extent. But we need to, I think sometimes the question is, what propels people to sexual offending behaviour? And actually a more pertinent question might be what helps convicted sex offenders to stop sex offending. So not just why they offend, but why do they stop offending? And I think then, again, we have to look at evidence available in other jurisdictions, as well as in the Irish context, that suggests that it's through reintegration, it's through reconnecting with society, by reconnecting or maintaining family ties, and through rehabilitation and engagement with those services and supports that have a vast improvement in terms of preventing recidivistic behaviour in the future. And that ultimately is what is going to be the benefit for society, to prevent people from reoffending in that context. So.
Thank you very much indeed. Yes, Detective Superintendent Hillman, please.
Very much. Yes, and in response to what you've said about the prevent strategy as well, I think it's very important, and we approach this with the two strategies running parallel, both the prevent and pursue strategies of what we need to do, rather than looking at them separately in isolation. And in terms of the prevent strategy, I think what we've also identified are the two types of offending, which is the online offending against the situational domestic offending. And certainly for the prevent strategy with online, the work that trying to be done collectively, very much with ourselves and PSNI, with a National Crime Agency, about engaging with service providers and with the education programmes, education of both young people, of parents and of society about how you can stay safe online. So I think they're very important, and there are things we're doing. Alongside that, the pursue aspect, and I think we've identified with ourselves, this is about having the tools in the toolkit, but applying those tools in a very risk-assessed, graduated response. So although some of the instances that we're talking about we do not use frequently, but actually when we do, it's with legal advice, it's through risk assessment, and having that tool to help keep young people safe is very important. And as we have outlined in the presentation, that we find that they work well with us in the north. And just finally, in terms of research, in terms of their reoffending, the Department of Justice in the north produced a research document in August this year. I think we've sent it as part of our documents, but I will double check that, Chair, if you would like that as well. And that's some evidence based about reoffending research.
If we haven't, it would be certainly a valuable tool in carrying out the work that we now have to do after this hearing. So thank you very much indeed for that, Paula. Thank you.
That's really useful,
yes.
Because my own feeling is we are framing this very much in the context of protecting the public, and if we're to actually do that, then it does need to be evidence-based, and that is absolutely critical. I'm curious as well. Well, I'd like to ask the PSNI in terms of the categories, and you were mentioning about category 3, that's the highest level and it kicks in, and who decides the categories at that earlier stage? Who carries that out? Is that just the PSNI? Is that the interagency level? Or just a little bit more detail on who decides that? And then maybe while you're at that, I know you did say very much tailored to the individual, and that's very helpful that it's done in a kind of a support of working with the offender and in terms of the disclosure issues, but you would presumably agree with the points made about confidentiality then as well, a little bit on maybe some of those two aspects.
Happy to do
my PSNI questions now, seeing as year regular attenders now as well. It's just on the foreign travel orders. Like, how many have you applied for, and what would be how would you come about that, that the person, has to tell you, or how does that work,
Okay. Oh, sorry.
Comes up with a fourth.
No, I won't. That's it. And the chair in the chamber is texting me to say I'll be over there in a few minutes. But anyway.
All right.
Happy for me to take
that? Please.
One of the key bodies for us is what's called our Local Area Public Protection Panels, or LAPs for short. And that is the process whereby post-conviction and sentence, either on release from prison or if the person isn't going through a custodial sentence, that panel meets and considers the risk. And that is a multi-agency panel. So, for example, pre-prison release, there'll be a LAP in prison that prison will chair, and we will be there alongside social service colleagues, probation, etc. And that goes through an actuarial assessment of risk, and that then leads to the categorisation. So that happens for every offender, and then depending on the categorisation, so if they're categorised at level 2, which is it's not medium risk, it's actually a higher risk than that, but of the 3, it's the one in the middle. Then there's another LAP then 16 weeks later to reassess the level and degree of risk. And that gives the individual tailoring. Those that are the category 3 highest risk, upon their release, I chair what's called, it's a multi-agency planning meeting. And that is as described with LAP, but it's very specific and very tailored around the individual who we consider as agencies poses a very real risk of reoffending. So that's the process, really.
Is that LAP one person or a number of people?
It's a number of people.
It's a number of people.
It's
So it wouldn't be one person wouldn't decide the assessment, or only, okay.
Yes, no, it's as we are now, sat around a table.
Okay.
Each of the bodies bringing forward their information. Prison,
With
for
the
example,
offender present?
No, the offender's not present.
Okay.
The offender's not present.
Daly, I'm going to invite
Sorry,
Brian
no,
to come in and wishes to add something to that.
In this jurisdiction, we would use some actuarial risk assessments as well as clinical judgment to make decisions on how we deal with people, because the research tells us that those who pose the greater risk demand greater intervention and greater concentration, and those who are of lower risk are dealt with in what we call a single agency way. So they would have either a probation officer or a Garda case manager dealing with them, and they wouldn't be part of the SORM process. We use two risk assessments in particular: a static risk assessment, which is called the Risk Matrix 2000, which is based on historical information. And that enables us to have a baseline categorisation in terms of low, medium, high or very high risk of reoffending over a longer period of time. And then we go into use what we call the stable and acute risk assessment. And going back to Deputy O'Caoláin, where he was talking about the causation, if you like, that risk assessment is a much more intensive assessment that takes place with the offender and would take place over a series of interviews and would look at a whole range of things in terms of their capacity for relationships, their hostility towards women, for example, whether they're impulsive in nature, whether they have good problem-solving skills, and then it looks at the whole sex issue as to whether their sex drive and preoccupation with sex is a factor underlying their offending, whether they use sex as a coping mechanism, and indeed whether they have deviant sexual preferences. So that information is garnered, and we use collateral information. We would look at the book of evidence from An Garda Síochána. We would work with the family of the offender where possible. If they've been in prison, we would liaise with our psychology colleagues in the prison service and our integrated sentence managers, and that enables us to build up a full picture. And obviously it is based on relationship, as our colleague says. So the better the relationship that we have with the offender, the greater the quality of information and the abilities then to target those particular areas, because the benefit of assessment is not just to give a label and a category, but it's to figure out what the management plan should be, what the case management plan should be, and what are those areas that we need to target, which will ensure no reoffending in the future and no victims. And we would do that with An Garda Síochána and with our colleagues in the local authorities and in Tusla. And we're all trained together, and indeed quite recently some of our colleagues went up to Northern Ireland to train some of the Pani people in the RM2000s. So there's a lot of cooperation between ourselves, but it wouldn't be in isolation. Frequently on an ongoing basis when we're doing our continuous assessments, it would be a member of An Garda Síochána and a probation officer who jointly meet with the offender, and as much as possible it's a collaborative effort with the offender to move forward.
Thank you. Deputy Daly. Oh, sorry. Did you wish to come back in?
No, there were other
Yeah,
questions that you had asked.
Of course.
And just to be clear, our pre-process before getting to the actual panel is exactly as outlined, which are actuarial assessments of risk, and the cooperation and joint training has been a real tangible and great partnership in recent years around how we develop that together.
On the foreign travel orders, like how many you've processed and what's the story there like?
Very, very few. In fact, in the past 2 years there have been none applied for. And I had mentioned earlier how there is, I suppose, a tiering of approach. So within the notification requirements within Northern Ireland, there's a requirement to notify around any intention to travel abroad. That, I suppose, is the first tier, and I suppose the layering of armour to try and prevent the offender going abroad to offend against children. I suppose the first aspect is actually those conversations with their offender manager, their designated risk manager, in terms of, they know a lot about them, to try and discourage that travel abroad. So they have to notify, and then, and really only then, when there is a serious concern, risk, that an application would be made, and that's very much subject to judicial scrutiny. So I suppose, as outlined by earlier contributors, it would only be and is only in extremis, because actually those other parts of the tapestry of tools and tactics have prevented us needing to go down that route.
Interesting. No, I have to go, but just on the, I mean, it strikes me the whole disclosure end is particularly key. I mean, Brian outlined very well how when you work with somebody, that's your best chance, and they have the supports and the family involved. And in that context, then, the management of this information being disclosed is really key in the manner in which the media and the public react to sex crimes. Understandably, because of how awful they are, but not helpful either. So that's critical to me, that the only people who should have this information are the people who need it for their protection, nobody else. Or else we are really fueling all of that, and I think that's key. But I could pose a question and then go and come back. But in that context, and because legally now under data protection there's a whole raft of rights, is that not a complicating factor, or has that been a barrier to developing some of these things because of the whole data protection issues, like, or has it been?
Where would you like to direct that, Deputy?
If anybody wants to take it, I may or may not. It brings a new, I suppose, problem into the whole disclosure area, like, or a new right to be weighed up also, So I just...
Okay.
I'll go and come back, but it'll be on the record and I'll be back.
Thanks very much. Yeah, obviously the issue of disclosure is a very sensitive one, and I would agree with the points made by Margaret in the context of she described that it's probably the provision that you're considering between the two pieces of legislation that needs the most caution and care in terms of how it's framed and how it would subsequently be implemented, because it does have a huge potential for harm as well as good. So it's really sensitive from that point of view. The General Data Protection Regulation, as we know, came into effect earlier this year, and there is within the legislation now that implements that specific provisions in relation to the Law Enforcement Directive, and that's probably the main area that we would be guided on as criminal justice agencies in relation to sharing of information.
Fine, thank you. And if I could just explain again, with the Chamber and other committees, members are in and out. It's just part of the madness, perhaps, of this of these houses. Well, Deputy Wallace, or just to explain, Senator Donala, none of your names are up in lights today because we've had an electronic issue over here, and we've introduced everybody else earlier. So this is Senator Niall O'Donnell, a member of our Senate, and you're indicating, Niall, would you like to go
just
next?
One very brief practical question,
Please.
Chair, and apologies, I was at another meeting and that's why I wasn't here for the presentation. But in terms of the reference to some of the practices around information sharing and assessment and disclosure, obviously in the past, I suppose the practical nature of life here, without getting in too deep to the politics of it, is that there is an invisible border, right? But the irony of that is that some people have exploited the border, some people have utilised the border in terms of their intentions, and obviously families and community impact straddle or cross the border. So I'm just wondering, in terms of the practical information sharing, when it comes to that issue of assessment and comes to that issue that you referenced, Mr. Henderson, if that ability to share information, that ability to come to, I suppose, a conclusion one way or the other, can operate on a cross-border basis, or if that is restricted to within each respective jurisdiction. If that question makes sense, I hope it does.
Paula, would you like to take that then?
No, most certainly. The crime we're talking about, and I talked about this yesterday in an interview, especially online crime, there aren't any borders because the online crime is happening on the other side of the world, and people are viewing images in the UK and Ireland. No, we have really good information sharing arrangements. We work very closely with our colleagues in Garda Síochána in that information sharing, and our colleague probation as well. You've heard we were actually down just last month. Our PAPANI coordinator, SORM, were up training using the same risk assessment tools, because this is about protecting children, and those information sharing protocols are working very well. And have been, and we have been looking at that, and going forward, we don't see, because of the legislation that we work under, we don't see that changing.
Okay.
Yes, please, Ita, you'd like to. Please.
We have very good information sharing protocols with our colleagues in the Probation Board Northern Ireland, and it's something that we have worked on for a number of years. And as you say, because we are on the one island and there is that movement of offenders, we need to manage that very carefully. With the data protection, it brings new challenges, but we're working on that at the moment around written agreements. And as Vivian referenced, the law enforcement directives gives us an authority in that. But we do it in two particular areas, where we have court reports, where we prepare reports for courts to the north, and vice versa, our colleagues in the Probation Board do for down south. We have an information sharing agreement that we can exchange that. And then if there are offenders moving between both jurisdictions, we also remain in close contact, and particularly then around the whole sex offender area, it's of critical importance.
And obviously that ability comes from that kind of macro higher level that enables you to do that. I'm wondering, just in terms of the context of this proposed legislation, if there's anything specific that we should be looking at in terms of good practice in other areas around the world that would actually help bolster that work, or, you know, are we content that that's enough, and that you know, information sharing is as it should be, and that's the level it has reached, or if there's anything that we can do to look at other examples, whether that's around Europe or more broadly, where we can help legislatively, certainly within the context of this jurisdiction, try and bolster that. It might be a question that's too much for today, but if people wanted to think about that and even come back to the committee at a later stage, I would appreciate that.
Right, okay. Deputy Wallace, would you like to?
Yeah, just thanks very much for coming, and I came here to listen rather than ask you questions, because obviously we have a lot to learn about. Very often there's knee-jerk reactions and, without enough thought. I'm just going to. Alan Todd was in here a few weeks ago, your Assistant Chief Constable, and it was very interesting to listen to him. And we spoke a good bit about the challenges of mental health, the role of the PS, that the PSNI actually play now, and so much of their time is taken up with it. And I asked him if he thought that there was enough training to actually prepare prepare members for engaging in such a complex area. And his answer was, well, you know, that we're probably doing more than we should be doing in this area, and that others need to be engaging more as well, and that that you couldn't set out to train people for all the different areas and that you actually engage in now. Does that is there an element in dealing with sex offenders also in this? I mean, is there a problem around? I mean, I just think that there's so much falling on your plate very often due to we would say in the south anyway. We have the Gardaí here now as well. A lot of times they're called to incidents that there is a mental health challenge dimension to it. That very often, if other services are failing to actually do what maybe we'd like them to do or what they should, so a lot of it is falling on the police service. And I'm just wondering if you think that there's too much on your plate to be actually dealing with this, or is there enough support in the other organisations for you to perform effectively?
If I could just add, it was also in the context of NGOs, but also in relation to some of the state apparatus, where it's a 9 to 5 Monday to Friday, and what happens is the Gardaí and the PSNI are probably carrying the can throughout the evening hours and the weekend in terms of mental health. And what was the other, I think another critical focus, Mick, was youth behaviour, just in general terms, that a lot of responsibility falls back on the respective policing services. So, please.
Yeah, thank you. I think if I just open up the answer on, it's really the issue of vulnerability which we're dealing with across all different kind of organisations, and we do a really significant amount of training around dealing with vulnerability and seeking to train officers and staff in recognising what potential vulnerabilities and risk areas may be for individuals and how they best deal with that. So I think corporately that is very much the focus, because for us to get very bespoke training on each and every separate issue isn't going to be possible, so we really seek to do that. I think within this field of sex offender management, and it'll be useful to get some input from my colleague Paula here around the designated risk manager role that happens within this, and how actually as a multi-agency forum they seek to do a lot of the active management. I think probably, Paula, you've the day-to-day management around that.
I certainly understand, and what Alan Todd would have been outlining, and was very much in response to the 24/7 uniform police response to calls. By the time you come into the arena of public protection and public protection branch, we are starting to work in the more specialist and the higher level of offending. So yes, undoubtedly, public protection is a growth area for PSNI. The Chief Constable has said that. It's an area where we have just put more resource, and we will continue to review that, both it and cybercrime. So while other areas of policing and PSNI are reducing, public protection and cyber and critical neighbourhoods and well-being, we're putting increasing resource to that. And I think that we have very good, across all areas of public protection, management of sex offenders, child abuse, social services. We have strong partner relationships. We have joint protocols, and the nature of the work we're doing allows those partnerships to work well. We are not, perhaps with the exception of our rape crime unit, doing calls on child abuse. We are getting some calls overnight, but we will not be getting the volume that the uniform colleagues would be getting. So I think our partnership relations and practices are very, very good. And they're certainly mature, especially the child abuse ones, adult safeguarding, which we're now moving into that arena, and the joint protocols with that. You talked about training. Yes, our detectives get, as well as their detective training, they get additional training on the area of work they're coming into, relevant to child abuse, adult safeguarding, management, sex offenders, so they're trained. And alongside that training, then, is their own wellbeing strategy of how we look after our people. So we need to look at that as well, because what they're being exposed to is a lot of things that people, fortunately, will never be exposed to in their lives, but they will be looking at images and dealing with things. So as well as a lot of people in their lifetime will not. So we have a wellbeing strategy which is above what our PSNI wellbeing strategy, about how we support them to do that work. So it's both the training, their environment, and their wellbeing, and then the working with partners is the collective approach to that.
Deputy Wallace.
Thanks very much. Just in relation to the south of Ireland, given the black and white approach that there's been kind of around this area, largely driven by a disappointing media, do you think that there's enough training and education to bring a holistic approach from those at the coalface making the decisions in the south of Ireland?
I'll go first. I suppose we've made a lot of progress in this area over the last number of years, and we really feel that it's about working collaboratively in an interagency way with the Gardaí and with our colleagues in the prison service that we can be most effective. And it starts at the pre-sentence stage, where a probation service may be doing a report for a court, right following through to the sentence management of that offender, targeting the areas that need to be addressed. And that follows through then into their management in the community. And that's why, particularly with this bill, we're particularly keen to bring SORM on a statutory footing, because it will further strengthen those good practices, really. We have SORMs in all of the 28 Garda divisions, and that's, like you asked about, on the coalface. That's our senior probation officers, the Gardaí, the TUSLA, the local authorities, each working together collaboratively for that public protection piece. We would also have had opportunities in the past where we would do joint training with all of those bodies. So even at its very simple, we're talking the same language, we want the same things, so people know where they're coming from. Each of us have our own job to do, but it's about us working together. So while we're never saying we're there, but we certainly have made progress in that area, and it's something we would really believe we need to keep going on to be effective, I think.
Yes, Vivian.
Yeah. I was just going to add to that and go back to Senator O'Donnell's question, I think it was, about where else can we learn from. And as an organisation, the Irish Probation Service would always have an eye, to what's happening internationally, and obviously we should learn from that. But I would just say that on this island, north and south, we have a lot to learn from each other, and we don't, in that sense, have to go very far frequently to be able to learn. Just last week, we had an event in our Dublin headquarters, and one of our colleagues from PSNI did a very interesting presentation in relation to their local interagency hubs that are being developed to address areas of vulnerability, including sexual offending, domestic violence, safeguarding, children and vulnerable adults, and so on. And I was particularly interested in that in the context that it would seem to me to show a lot of promise in further encouraging that level of interagency cooperation, which, as Ita said, we would welcome being put on a more statutory basis under the present legislation, but also encouraging and facilitating that. And going back to the question raised earlier on by Deputy O'Caoláin, what struck me about the hubs in Northern Ireland is that, as well as managing situations and offenders that we already know about, it also feeds into very much a preventive approach and facilitates all the agencies involved. And very often it is people like the police who end up at 2 a.m. on the Sunday morning dealing with a particular incident. But through these local hubs where situations are being monitored, that can be addressed in a kind of a preemptive way. So, as I said, very often I think we don't have to look too far in terms of whether it's north or south in learning from what we can do better.
Thank you for that. Yes, Brian.
Again, just to refer to Deputy Wallace's comments. I mean, I think it is obviously more difficult if people are undergoing emotional collapse to work with them in a positive way, because that becomes the priority. The mental health becomes the priority issue. Similarly, some of the programmes that we have in operation to work with sex offenders demand a certain level of intellectual ability. So where people have issues with intellectual disability, we have to deal with them in a different way. But all the time we are recognising that an interagency approach is what's necessary. So we're talking with our colleagues in the mental health services constantly and gaining their support. And as my colleagues have said, when it's on a statutory basis, to bring those players in even more forcefully, in a sense, because the powers will be there.
Thank you. Oh, sorry, by all means, on the same issue. Yeah.
Are you finished?
No, go ahead. Yeah.
No, just to say, in terms of the hubs, I think that it's positive to cite that as an example. I've actually asked that through the chair explore us getting the opportunity, because I think it's important that we have the opportunity to see the practicalities of this at work. And just to make the point of Vivian, he's right, I agree with him, and I would always encourage that element. And I think the great benefit has been having the PSNI and other organisations from the north in the room together with colleagues in the south. That has really, again, allowed us to look at examples of good practice and also examples of where each other can maybe get things right. So I think the more that point can be made at each meeting with every organisation right across the board, the better. So that was it, Chair.
Thank you for that. Now, Mick, would you like to? Yeah.
In relation to, I'll ask Margaret first, in relation to Maureen's bill, do you think in its present form that it's a bit on the oppressive side?
I think that it definitely needs to be strengthened if it is something that is going to be put on the statute books. I think that there are a number of issues inherent in the actual wording of the proposed provision that needs to be cognizant of the implications for constitutional and human rights challenges, because currently the wording of the provisions are not strong enough, I don't think, to live up to any potential future challenges on the grounds of the right to travel, the right to liberty in the context of freedom of movement, and to privacy rights in particular. And I think in relation to that, you have to look at jurisprudence of the European Court on Human Rights in relation to deprivations or restrictions placed upon freedom of movement, and the circumstances where that has been deemed to be a violation. Oppressive or unnecessary restrictions on somebody's freedom of movement have been found to be a violation of Article 5 under the European Convention. So I think what we need to do is we need to establish terminology that allows us to incorporate that issue of necessity and proportionality within the meaning of the restriction or the prohibition on the travel abroad, and that is to prevent it from being open to challenge with regard to its arbitrariness. And I think that, following on from that point, it's just not clear what we mean by restriction. What exactly is restriction supposed to be? In the present form, it assumes that it's just the judge who is supposed to decide what exactly going to happen in terms of allowing the person to travel or not allow them to travel. And that's unsatisfactory because, again, it renders it slightly unclear, arguably arbitrary. There should be some aspect of it being based upon evidence adduced, so that there is a specific risk, a specifically identifiable risk that has come to the attention based upon perhaps the report of a probation officer or something to that effect, that there is a need, that it comes within the issue of necessity and proportionality under both our Constitution and under the European Convention. And I think the purpose of the travel needs to be considered, and I think that could be something that alters or changes the nature of the wording of the current provision, that if we incorporate certain requirements for what a court has to take into consideration, that could lend credit to the fact that this is necessary, it's not arbitrary, and it takes into account and is cognizant of the fact that sometimes people might need to travel in order to procure work or for as part of their job, so it doesn't impinge upon the right to earn a livelihood, and also in order to enjoy those family rights under Article 8 and under our own Constitution as well. So I think the wording needs to be looked at in that context. We need to be clear on what we mean by restriction, and we also, the overarching I hate to use the word problem here, but the overarching concept that we need to consider as well is a resources issue. So if we're talking about restrictions to perhaps a certain destination or restriction in the context of a time frame, then there needs to be a way of implementing that effectively. And that involves, to some extent, supervision. So who is supposed to supervise? Is it the Gardaí, is it the probation service, is it the court? And does that involve the court then having to come back and make subsequent orders or judgments against the individual in the event that they fall out of line, with those restrictions? It also might involve authorities in another jurisdiction having to be involved in supervision of our citizens, and again that becomes a resources issue. Of course it becomes an issue of communication, and that's very important, but it may become a practical issue as well that might be difficult to resolve. So those are the things I think we need to be cognizant of if this is something that is going to move forward and be framed in statute.
Thank you for that. Deputy Wallace.
Just for everyone else that might, was I right in saying you were saying that the foreign travel order hasn't been used in 2 years? So on that basis, and I mean Northern Ireland isn't that different from the south of Ireland. I mean in general, I mean, do you think that Maureen's bill is a little bit unnecessary, or do you think that it's something that we should progress?
Would anyone like to take up on that from the PSNI team first, perhaps? I think that's only if you're at ease in making any direct response to the particular question. It's entirely your decision.
No, it's fine, thank you. I think it's a useful piece of legislation to have, so as if on that risk-based decision-making criteria that comes in place, that if it is required, we can. I think my colleague highlighted very well within the notification process the expectations and requirements that we have in place, that individuals are required to notify the police in advance if they intend to leave the registered home address for more than 3 days or to travel elsewhere in the United Kingdom. We have all travel outside the United Kingdom except to the Republic of Ireland. So we do have those requirements through the notification orders, and I think those do work very well, and we do keep coming back to the processes that are in place around the actual offender management and with the designated risk managers who do seek to build those relationships and remind people of the requirements to do it, and they get to know them, get to know their movements. Is that fair enough?
Would you like to add something to that?
I was just going to add, in terms of that graduated response, in terms of the foreign travel order, and again, we would apply to the court, but there have to be grounds to believe the offender is travelling, that the offender travelling to that certain country poses a risk to children. So there are criteria that we need to meet if we were going to, or evidence we would need to present. And again, I think some of the comments that already made about looking at the country in question and the purpose of the visit would all need to be taken into account. You wanted to say something?
Yes, I mean, all of the points are absolutely right, and we haven't used it. I feel there's a great importance to it in when faced with a recidivist sex offender who is determined to do that, ask yourselves what would be the provision to prevent that happening. So having it there, I think is important, taking absolutely the points around the proportionality and necessity of it, but I think it is an essential part of the armour.
Okay, and to the probation service, please.
Yeah, while I feel that Margaret has made very valid points in relation specifically to the need to avoid arbitrariness on the one hand and to ensure necessity and proportionality, for example, I would agree with our PSNI colleagues that this piece of legislation would provide quite useful specific measures. In the context, for a start, that it's possible, as far as I would be aware, that a judge could make such an order, for example, as part of a post-release supervision order as things stand, and yet this proposed legislation would provide very specific measures for how that should be done. I do think that, as is often the case, the way whatever piece of legislation goes through is further developed, planned for, and the various rules, for example, of court and jurisprudence and so on develops, and also the way that the different agencies arrange their work around that. For example, in the context of if a probation officer was preparing an assessment for court, in particular cases, they might address this issue of travel or not travelling. It is useful from our point of view that the legislation provides that any such decision would always be made by a judge. And I do think the point that Margaret raised about resources is important, and equally the issue about who would supervise somebody in the context of them being allowed to travel. And I would expect, I don't want to open a whole other area of legislative debate, but there is legislation due to go through the Oireachtas in relation to the transfer of probation decisions between EU member states. Now, that doesn't deal with the upcoming scenario next year in relation to the United Kingdom, but there will be legislation here to provide for the mutual recognition and transfer of supervision of probation type orders in the various EU member states. So that would be one element of how that could be addressed.
All right, thank you. We're good to go?
Yeah, I was just going to ask Caroline if her take on the same thing.
Well, I think I agree with Vivian that Margaret made some very valid points, and I feel my gut feeling was kind of justified as I listened to her. It's important that such a provision is framed properly. I think it is useful to have, even if only one offender every 5 years has a foreign travel order or Section 4 or whatever made against them, because you will always get people who have that propensity, and where you can produce reams of evidence that there's children going to be at risk in a particular destination, or more than one destination, or maybe even a particular child in a particular foreign country. There will be those people. So I just think in general the principle is the more weapons there are in the armoury for people who must assess and manage risk over a period of time, the better. You know, so I think it would be good to have, but it's important that it's well framed to resist, to be insulated against legal challenge.
Thank you.
Thanks very much.
All right, Deputy Wallace, thank you very much for those series of questions. And our final contributor, Deputy Donegal O'Leary.
Thanks very much, Chair. I suppose firstly to apologise, I had to step out there for a chunk in the middle there just because I had to attend another meeting. I suppose a lot of the questions have very likely been covered already, and I'll look back over the transcript, so any of the questions that I've asked, if you have already addressed them, you can feel free to refer back to the transcript and I can pick out the answer myself. Just in relation to I suppose following on from Deputy Wallace's questions, and I think there's a broad consensus that the principle of the Deputy O'Sullivan's bill, that the principle behind it is of value, that it might be something that might not be used very frequently, but that it is of use on those infrequent occasions when it's used. There seems to be a consensus on that. I suppose just ask maybe specifically Dr. Fitzgerald O'Reilly, but also anyone else who has a view, like technically and legislatively you've identified a number of significant flaws with it. Do you believe that those flaws can be rectified? Like, I mean, is the bill, in your view, is the wording, I suppose, so compromised that it would be better start again, or actually is there a basis there, if we're all in agreement with the principle of what it's trying to do, to remedy it and move ahead to committee stage?
All right. Please.
Yeah, I think that it provides a backdrop. I think the context, the idea is sound, but the way in which it's currently framed, I think that it's very exposed to being challenged. So to some extent, you could build upon it and rehash it out, reframe it. In some ways, it might be better to consider it as an aspect of the government bill, as a proposed new provision within that, and then look at how that might be worded, more narrowly construed, constructed more tightly with regard to those issues that I mentioned before. And perhaps that might be what my feeling on it would be, that perhaps it needs to be within the government bill as a separate provision, as a new provision, and framed differently in the context of what it hopes to achieve and how it's going to actually achieve that. That's my simplistic answer to that question.
I think the earlier response has probably covered the range when Deputy Wallace was asking that. I think there is a general acceptance that with some amendment, some more thoughtful consideration, that the bill has merit in proceeding.
Very good. My next question is there just related to, and I start with Dr. O'Reilly, and perhaps Ms. Coonahan could add to that as well, maybe, and anyone else who wants that, just into the area of electronic tagging. I suppose, Dr. Firstly, like you say, that there is a lack of research in this area of the effectiveness of tagging. Like, I suppose, that being the case, I presume there is a limited amount of research, whether on a low scale, or I suppose with, I don't know, poor quality control or whatever. Like, that research which does exist, what does that tell us?
Well, you're absolutely correct. There is some limited research there available, both in Europe and in the US, in relation to electronic tagging of high-risk sex offenders. And I suppose that's the point, because there is research done in relation to tagging of high-risk offenders, but it's specifically in the context of high-risk sex offenders that we are considering this prospect. So that's a very different nature of research and empirical data. And again, if I could use the US research, because that's where most of the research has tended to come from, again, a very different context, a very different jurisdiction, but the basic principle is the same, insofar as it permits electronic tagging of those who are considered to be at risk. And now, again, the categorisation of risk can vary considerably in accordance with state jurisdiction. But the idea is that it's there to monitor and to control and to deter from sexual recidivism. And all of the research, whether it's in favour of keeping tabs upon high-risk sex offenders or not, categorically acknowledges that there is no or limited difference in terms of recidivism rates for those who are electronically tagged to those who aren't electronically tagged. So there is no impact in terms of deterrence, there's no impact in terms of reducing recidivism. The one thing that is of note, which may be of value, is that I suppose there's two areas. One is in the context of a very carefully strategised post-release risk assessment strategy around helping the offender to reintegrate into the community, and again, specifically in relation to offenders who are being subject to supervision. So there is some evidence to suggest that it can be helpful as one part of a more holistic, coherent re-entry strategy. But again, it's in the short term, and there is some evidence to suggest that it may be more useful for first-time offenders than for repeat offenders. The other issue is in relation to where the monitoring reveals a new crime. Again, even if there is a suggestion that this was a good thing, it tended to reveal crime in relation to breaches of registration orders. Now, that in itself may hold value, but in terms of the broader long-term issue of preventing sexual recidivism, there wasn't any appreciable impact upon that. So yes, it has some limited impact and usefulness in terms of ensuring to some extent compliance, or to identifying non-compliance with registration requirements, and that can be a very positive thing, that can be a very good thing. In terms of recidivism, in terms of deterrence, it has no appreciable value. The last thing that the research tells us is that electronic monitoring is very costly, and again, there is a kind of a general consensus that it's not cost effective if you compare it with what the objectives are. So if you're looking at the objective in terms of preventing recidivism, preventing sending somebody back to imprisonment, then there isn't any cost neutralisation value there in terms of monitoring the person via GPS or some other form. So again, the research concludes that it has to be questioned as to whether we want to provide this type of monitoring, considering its lack of effectiveness, as empirically proven, and then the fact that it is so costly to actually implement. So that's the general consensus of the research there with regard to that. And I think you should be mindful of that.
Sorry, Mark. Thank you very much indeed for that. Caroline, would you like to take up?
Well, I haven't a great deal to add to that, really, Deputy. What I've read on this, I have to say, goes back a little while, but it doesn't differ a lot in essence from what Margaret has just said. I mean, my understanding is it can be useful to have somebody monitored electronically for a fairly short period, as Margaret was saying, and it can be useful in situations where other, how shall I say, softer intervention hasn't worked, where the relationship between the offender and his supervisor in the probation service hasn't worked, not through any fault of the probation service, but where you do have somebody who's a diehard offender who is determined that they're going to commit crimes one way or another. And it can be helpful, I understand, where the either the criminal behaviour or the non-compliance with the particular order is associated with a particular geographic location. I suppose I'd be saying, yeah, well, it's all very fine if the electronic monitoring system tells you that so-and-so isn't any longer going to this place or that place or the other place. That's great, but don't be lulled into any sense of false security. It may be that he is now committing offences in an unmonitored zone. You know, again, it's that point which has come up so often this morning about there is no silver bullet. In certain situations, for certain offenders, as part of an overall risk management strategy, it can be helpful, I'm sure, but it has, I would say, strictly defined in terms of time and geographical area usefulness from what I've read.
Okay, thanks, Caroline. Now, it's optional, you know, it may or may not be, you know, a comfortable issue.
Chair, I might add a bit to that, that maybe might be that the parole board and...
All right, and I'll come to you, Ita, just when...
And then you can subsume maybe observations on our previous questions. I suppose, I suppose on a practical level, it occurs to me that, I'm not sure, maybe the research reflects this or doesn't reflect this, but it seems to me that any electronic system is only as good as the human resources behind it to actually address a breach of registration or whatever, a breach of conditions. I suppose we have enough difficulty in this jurisdiction with breaches of bail, it's not actually the bail conditions very often that are the problem, it's the ability of the Gardaí to go out and address, somebody who's not complying with their breaches of bail. In the same way, if there are conditions on release from prison and following a conviction, and if you have electronic tagging as part of that, but you don't actually have the resources to then go and pursue somebody whose electronic tagging is showing up in the system, that this person is in places that they're not meant to be, or they're not showing up at the places at the guard station or whatever. Look, I suppose just a general comment to that. I suppose the other one is, I'm not quite sure what statement I saw it in, but in one of the statements there was commentary on the stigmatising effect of tagging. Is there some experience in some jurisdictions of how that could be done more discreetly or whatever, in terms of design and all that kind of stuff?
Well, Ida, you had your hand up. Would you like to take the full package now?
Thank you. I suppose firstly we would absolutely agree with you in the probation service that it's not just simply a matter of putting on a tag and walking away. And as you say, it is about the management of that as well, and the human resources behind it and the monitoring of it. And we would feel that if introducing electronic monitoring as part of a risk management strategy, as a planned programme of intervention, would be the most effective way of doing that. And certainly from other jurisdictions that has been proved that it's when it's integrated with a supervision package, it can be at its most effective. And I think what the legislation is advocating is that there would be a possibility as part of a post-release supervision order that somebody could be electronically tagged for a period of 6 months. And we in the probation service would see a value in that in some instances where if somebody had, say, an exclusion to be away from a particular area, or if we knew that their risk behaviour was associated perhaps maybe with children, to have an exclusion zone to be away from playgrounds, or victims, to have somebody kept away from a victim, there can be a value there as well. But it's very much around the monitoring of that, and that needs to be part of a planned package. And also, as Caroline said, there could be some instances where when somebody is in custody and coming out in a post-release supervision order, if there are certain risk factors that are noticed while somebody is in custody, and maybe to encourage that reintegration for that period of 6 months and tighter monitoring, we would see a value in perhaps the electronic tagging in those instances.
Thank you. Okay, Deputy, I think that I don't know that you're. No, I think the indication was that you didn't wish to add anything further to that particular point.
No, as outlined in our statement, there are general powers in relation to offenders, as outlined. Nothing specific in relation to section offenders.
Thanks. That's grand, Ryan. No, that's my read of it too.
Okay, great. Just two final questions, I suppose. Maybe just in relation to the issue of notification. Like, I mean, do you believe that this is an open question really, is the legislation there, the government legislation, like, I mean, the heads of it, is it strong enough in terms of where somebody is notified and that information is passed on to somebody that it shouldn't be passed on for, there's a breach of the circumstances in which that notification should happen? Like, I mean, is that covered under data protection law, or, I mean, do we need to strengthen this legislation here to ensure that people, where they receive notification, treat it properly, confidentially and with discretion?
The area was addressed earlier, including GDPR. We did, because I think you'll find that there is substantive material there on the record out of earlier questions posed, Donncha, in deference to. You had a final, another question?
The final question, I suppose, is mostly for the parole board. I suppose, look, in terms of, and like, I mean, this is on the theme of maybe some of this legislation, but like, I mean, it's something that presents occasionally, and very likely this was covered earlier as well, and if so, that's fine, you can refer to that. But like, in circumstances where somebody who's high profile, who's committed sexual offences, and the media, there's media commentary on this and so on, and obviously that becomes an issue of controversy, sometimes based on a phantom in communities, based on, you know, inaccurate rumours and so on. Like, I mean, this is an issue that presents itself every so often, and obviously a big part of that needs to be around education, I think, perhaps more responsible conduct by the media. But I suppose it's not immediately obvious to me, and it might be to others, like, what is the right environment for somebody coming out of prison who is well known to have committed certain offences? Like, I mean, any external community that they're not familiar with, that they become moved into, and if the public becomes aware, then that creates a controversy and difficulty and perhaps a threat to the offender and their welfare. But, like, I mean, often the issue is if that person returns to their home community, then perhaps the victims of this offender are in that area and they can come into contact or in confrontation and so on. I'm not asking this from a position of having a preconceived notion, but I have to say, when these controversies arise, I'm not necessarily entirely sure myself what is it, where is the ideal location or the ideal setting for that person in the community at large now that they've been released from prison.
Okay, final question. There we are. Would somebody like to open in responding to that? Would I be... Right, Vivian, please.
Yeah, maybe to take the final question first, Deputy, and that was where is an ideal location, and probably the short answer is that there is no ideal location. And at the same time, the vast majority, if not all, sex offenders who go to jail come out again. So they are coming out, no matter what they've done, and they will have undoubtedly received a proportionate sentence. the sentence is the sentence, and the best way we can try to ensure that they don't go on to re-offend is through having the appropriate controls and monitoring in place, but also to trying to ensure that there is a level of reintegration in their community. The issue that arises from time to time, and thankfully it's in a small number of cases in the overall context, but it certainly does arise, and it does impact, as I said earlier, on our work. The media that sometimes publicise these high-profile cases would argue, in my experience, that people have a right to know that somebody very dangerous might be living in their area. I would argue that the individual has the right as well to make, in collaboration with the various agencies, the best effort at resettlement and reintegration. And as Ita and Brian mentioned earlier on, in the small, thankfully, number of really serious, very, very highest profile and highest risk offenders, they do, on release, receive the highest level of attention from both the police, probation service, and the various other services. So, people should be assured that when an offender at that highest level is released back into the community, that we are all doing our best to ensure that person is monitored and controlled on the one hand, and at the same time helped to ensure that they reintegrate and don't reoffend again. So, there isn't an ideal scenario, there isn't an ideal location, but unless we all work together to try and ensure the appropriate reintegration of the individual, we're actually taking backward steps.
Thank you, Vivian. Brian, and maybe somebody from the PSNI might like to add to it. Brian?
Well, just a quick one. I mean, if we flip risk assessment or the risks on its head, it's about what positive protective factors can be put in place. And we know that pro-social influences is a positive factor. We know that social acceptance rather than social rejection is a positive factor. And in the probation service, we work with an NGO and we provide COSA, which is Circles of Support and Accountability, where we have volunteers who are recruited and trained and supported to work with isolated sex offenders to provide that social network and social support, while at the same time monitoring behaviour. And that circle, which would have a core member, which is our sex offender, would work closely with an outer circle that consists of professionals such as Garda Síochána and ourselves and TUSLA. But it's a recognition that social isolation is a risk factor. Social acceptance in some shape or form, and as much as possible, is a protective factor. And it's like recent research that came out looking at desistance with child sex offenders in Manchester indicated that employment is one of the biggest protective factors in terms of desistance from future offending. So it's the contrary to social isolation and becoming totally disregarded within communities. We're not saying that the ideal place is to go back to their own community, because quite frequently the offending has taken place within communities, and the victims are known, or the perpetrator is known to the victims, whether it's in family or within tight communities, and it is a difficulty for them to go back into that area. But we work with our colleagues in local authorities to try and come up with housing solution, but then we try and put in wraparound services to, as I say, develop those positive factors and to prevent social isolation, which leads to greater risk.
Thank you, Brian. Would anybody like to, or you, maybe some of the questions may not.
Only to build really on what colleagues have said, and within the Northern Ireland context, we're fortunate that we have a network of hostel accommodation, which can provide that shield, I suppose, the protective shield for offenders, and then allow those connections to be made around employment, around the right support, etc. from them, and that works well. But of course, it's limited, and we would always want more of those. So I think they are an important part of that process of reintegration, prevention and assistance.
Thank you for that. Thank you for that. Caroline and Margaret, would you like to add to?
Just only to say that as things stand at the moment under Section 46 of the Criminal Law Sexual Offences Act 2017, probation officers as well as Gardaí may apply, and indeed victims may apply if necessary once somebody has been released from prison for a harassment order to prevent the sex offender from, I'm just quoting from the somewhat legal language here, approaching within such distance as the court shall specify the place of residence or employment of the victim or any other place frequented by the victim as the court deems appropriate for a period of time, maximum 12 months, and that's a good protection to know about, and it goes some way, a good way, I think, to allay the fears of victims when perpetrators come back into the community, you know. But it's very reassuring to me also to hear that the probation service, in tandem with local authorities, does where they can do everything possible to offer people's sex offenders housing solutions elsewhere, as having somebody in the local community is very difficult for victims, as you can imagine.
Thank you, Caroline. Margaret, would you like the last word?
Briefly to add, and just to echo the comments, you know, of the panel before it, just in relation to the fact that, you know, it is notable that sex offenders, once they are released, are at a higher risk of homelessness, and of course homelessness is one of the recidivistic factors that often comes into play. And there's another problem as well, even though, you know, such harassment orders are of course a positive step. I think it's worth noting that that might in some way distance an offender from reconnecting with their family as well, you know, and again forming those family ties can be a really important way of overcoming the kind of stigmatic narrative of the previous sexual offending. And again, this is for people who want to overcome that, you know, that previous behaviour and want to be integrated, and it's about encouraging, I suppose, the maintaining of those relationships where appropriate in order to facilitate reintegration. So I'm just echoing, I suppose, what has been said already.
Thank you for that. Thank you, Deputy O'Leary. Well, we're at the end. Well, you're at the end. We're only at the start, because the hard work comes next. We have a report to prepare, and we have to get to a point of agreement on all of this. That includes colleagues who didn't participate today, but they will inform themselves from your respective submissions and your oral contribution here today. Assistant Chief Constable Barbara, may I say that there were on 2 occasions an interesting reference to you made, and I don't know if you picked up on it, but in the context of other former colleagues who have made a new home for themselves here, I was wondering how you would react to having been addressed as Assistant Commissioner, and it happened twice here today. Brian put his hand up, but Jim started it there, and I'm sure that Paul and Ryan will have a bit of fun with you on the way home over that. You hadn't brought them in on your confidence. So there we are. We'll watch that space. Okay. We'll watch that space. To Vivian, to Ita and to Brian from the Probation Service, thank you very much indeed. To Barbara, to Paula and to Ryan, thank you for journeying here and being with us today, and for your contribution and safe home. And to Caroline, thank you, and to the Rape Crisis Network. And to Margaret, the University of Limerick School of Law, they must be well noted as a place to be considered by prospective students in law in the future. So to say well done to you for that. So a thank you to all our guests here today, and to our members for participating. The Joint Committee is adjourned until 9 a.m. on Wednesday the 5th of December, and we'll meet you all again tomorrow for Select at 2:30. Thank you very much indeed. Thank you.